Oh, the weather outside is frightful, but the fire is so delightful. And since we've no place to go, let it snow, let it snow, let it snow. Man, it doesn't show signs of stopping, and I brought me some corn for popping. The lights are turned way down low. Let it snow, let it snow. When we finally kiss goodnight, how I'll hate going out in the storm. But if you really hold me tight, all the way home I'll be warm. And the fire is slowly dying, and my dear, we're still goodbying. But as long as you love me so, let it snow and snow. When we finally kiss goodnight, how I'll hate going out in the storm. But if you really grab me tight, all the way home I'll be warm. Oh, the fire is slowly dying, and my dear, we're still goodbying. But as long as you love me so, let it snow, let it snow, let it snow.
Hey, what's going on, everybody? It is Artie of Artie's Corporate Fiction. Oh, stop that for now. Welcome. It's Wednesday. Happy Wednesday to you guys. Happy Hump Day. I apologize for not streaming the last couple day, last 2 days. Just had a, kind of rough spots, rough patches. It happens. But I'm back to give you a long-awaited update on the Queen of Canada, Romana Didulo, who's gotten herself into additional antics, and I still haven't been able to confirm, but there may or may not be an actual arrest warrant out for her, but I'm not sure. I don't think it's been confirmed just yet. But we're going to take a look at that, and we're also going to take a look at another a separate Sovstic guru that I've referenced before on this channel, Mr. Alphonse Fagiolo. He is a Pennsylvania-based sovereign citizen guru who insists that he's not a sovereign citizen guru, but he tries to get so he tried to. Well, you know what? I'll wait until we get to that portion of the video, and I'll give you guys a rundown of his situation. And if there's enough time, I might watch a video, a recent court video or two, to round things out. But let's start with Miss Her Majesty, I should say. Sorry, I shouldn't say Miss. I should refer to her by her proper title. I'm sorry, Mandy. I apologize. I completely forgot to message you that I was gonna bump it up earlier. I apologize. I'm so sorry. Where is it? So one of the first things that this actually caught a lot of flack was apparently they got harassed by I guess public officials from the town. I thought this was a fake name, but it actually is called Medicine Hat Canada. But apparently they were out to go get, like, I guess supplies at a local grocery store, and apparently members of the town were video recording them inside the supermarket, and they did not take kindly to that.
You're not harassing me. You're harassing me. I'm shopping. You're stalking me. Okay, you're stalking me. That camera is on.
These are like short bits.
Harassing me, okay? You're harassing us. You're coming here and harassing us, okay? You're harassing us. You're harassing us.
I am on your...
Move away from us, okay? You're harassing us.
Oh, was he about to say he's on her execution list? Yeah, by the way, the Queen Tadulo likes to hand out lists of public officials, a lot of public officials, who and she lists the names of public officials for execution according to her decree. I think that's what he was about to say before the video cut out.
Okay, these people are harassing us, okay? Okay? These people are...
Yeah, okay, so he did just say that. The camera woman sounds like Tadulo herself. The person behind the camera sounds like Tadulo.
Are harassing us here. We're shopping inside the store, okay?
The call from Richmond.
Why would you like me?
Why is it not? Why the alert's not working for me? That's shameful. Hang on. But thank you very much, everybody, for the gifted membership. Thomas, thank you for the gifted membership, of course. And thank you, all of you, for your membership anniversaries as well. Arian Rod, thank you. 31 months of support.
Executed. Can you just answer why you want me executed? Is there a reason why you want me executed?
These people here are harassing us.
It sounds like she does her own shopping.
Harassing me.
Oh, this is a repost. So, as far as I know, as far as what we're, my understanding is that they are still holed up in this compound, aka like I think it's like a former school, that they've been squatting on for like the last several months.
Training day 2 for the newly arrived team members, ladies.
Kira, thank you for the $4.99.
Learning to go through the...
Apparently, new folks. Again, apparently there are new people joining her cause. Sadly. So those are the... What is this one?
Tom, out of respect for you, I'm not going to record this.
I am. Tom,
This?
this man has been very rude
What's
to
going on
us.
here, Tom?
Get the fuck out of your chest.
Seriously?
You're trespassing.
I'm
Chad
trespassing
myself.
now.
You're trespassing.
Okay,
It's right
well,
here.
hold on a second, Tom. I am going to record this.
No, you're not.
I think Tom is the owner of that property owner. Yes, Timbo's correct. I think the individual in the truck is the owner of that property and is allowing Romana to squat there. So actually, technically, they're not squatting. They have permission from the owner to be there. They're not trespassed. This individual is the same guy from the grocery store who's, I think he's a public official in the local town. The owner of the building is a supporter of Queen Tadulo and has given her and her cult permission to squat in the on the property. That's why they haven't been kicked out.
Okay, you know what? Because of our history and our family and how long we've gone back.
Yep. I'll tell you what, Chad. See where this goes back to? When you came back from Thunder Bay. Okay? When you came back to Richmond here. Your wife made it quite clear she did not want me or Johnny in your fucking vineyard when we were farming your mother's land.
Are you kidding me, Tom?
Yes.
That is not true.
Fucking right, that's
No,
true.
it's not true.
Yes, it is.
You know what, Tom? I honestly can't believe this.
I'll tell you what happened here.
I'm going to record this. They're recording it. Tom, they're recording it. I'm
Get me out
recording
of the
it.
picture.
No,
Get
you
me out.
want to say it? Then let's talk about it. Let's talk real.
Put the phone away.
Then tell them to fuck off right now. And me and you will talk man to man like neighbors do.
Let's go back here.
Tell them to fuck off and let's talk right here, Tom.
You and I go on the other side of the yard and talk.
I'm not okay with that. I want you to have to look at this shit when me and you were talking man to man.
No.
Yes.
I know what's here.
Tom.
I'll tell you what
My
happened.
God.
I'll tell you what happened, Chad. The only street
Tom, I'm gonna start videoing if they don't leave.
You're being
I'm
told you're
Tom.
being unreasonable
This
here.
is not ask them to leave. This is your. I'm not telling you to ask them to leave the yard. I'm telling you to ask them to leave the truck while me and you talk.
Let's go over to the other side of the yard. Let's get off this piece of property right here. Let's go over there for the bin.
Looks
I
like
see
I
what-
wasn't lying. Looks like I wasn't
That's
lying.
right. Good
That's
for
right.
you.
Thank you.
Let's go have a talk, Tom.
Okay.
Which one was this one? Oh, they're still doing RV training. She's recording them doing RV training, and then the rest of it is cringe. Random uploads from alternative media and soft-sittery. So the other person I went to for the update is Dr. Oh, I'm going to butcher her name. I am so sorry. Dr. Sarteshi? Oh God, is that how you pronounce your name? I'm so sorry. She Sarteshi. I think that's how I pronounce her name. She is actually a professor of criminology, and she actually specializes. Oh, I'm not. You guys can't even see it. Hold on a second. Oh wait, you guys can't. And she specializes actually in sovereign citizens specifically. I've actually asked her like several times if she ever wanted to come on and have an interview or discussion. She says she's open to it, but external circumstances prohibit her from being able to do that just yet. But I'm hoping that that it'll happen soon. Even when I was flattered when I first reached out to her. She's I'm asking her to come on. She said she couldn't, but she said that she actually was a fan or follower of mine, so I appreciate that. Eventually, I believe actually Gary. I think they are very aware of her. Actually, as a matter of fact, here, this is what her is there truth. I don't know if you guys can read it. I'm gonna. Is there truth to the rumors of arrests related to gang stalking of QR, Queen Romana, and team this morning? My friend in Alberta told me there were several arrested last night and this morning, and that the Goblin from Community TV was one of them. I also heard Dr. Sarteshi and Dr. Celestini haven't been active today. Can we get an update? So yes, they are actually aware of the good doctor. ASN Sour Citizen Group complaining about all the people who ripped them off. It's a lot. Scammers Paradise. Yes, it is. I paid a lot. I paid $25. You paid $2,500 for a land patent in the beginning of August. Was told to do my research on my own. That's all the further it went. Contacted the main person because he was put on a new person in to complete it. Heard nothing. Time for a refund. Yeah, who works close to David and Ron. David, I assume it's David Straight. Yes, these guys are scammers. All of these gurus. David Straight, I think Ron, oh my God, what's his last, I forget his last name, but Ron is also a guru. Oh my God, Winston. Oh, geez. Oh my God. All right, I'll be right back. I gotta clean out that litter box. I am so sorry. Goodness. I'll be right back. To get him to stop, because now he's cosplaying as a fucking Spectre. They were something else.
to do this. Look, I'm fed up with all of it. Companies
Hey, Doug. Oh, I'm back. All right, I'm back. Oh, damn it. Hey. Damn, that sounded. Oh, man. What in the world? Oh. Ugh. It ain't like I'm feeding Winston something different. Goodness. Anyway, where was I? Oh, there it is. A Didulo follower. This could. Oh, sovereign citizen is a Zionist Nazi creation. So I guess they're exchanging talking points from Yusuf L. Didulo says criminal charges have been laid. She's ordering global allied special forces, Kingdom of Canada's allied forces, North America's allied special forces, White Hats military. Charges been filed against the gang members who targeted, gang assault, ambush, harass, held hostage, kidnapped, terrorized, incited hatred, hate crime, and violence against the Queen at a local shopping center. So. But people in chat are saying that she has been arrested. Or no, not arrested, but there is actually a warrant out for her. Sending cease and desist letters to police officers. Sakude, thank you for the $5. City coordinators are being encouraged to call the Medicine Hat RCMP. The phone number was provided. This was 3 days ago. Okay, Didulo's people are claiming that there is an arrest warrant out for her, but no confirmation yet. Yeah. So apparently there might be an actual warrant out for her, but we'll see. Interesting. So that's the next update. The unfortunate reality is that she and her ilk cannot be trespassed from that compound because they have permission from the compound, from the property owner to stay there. But there may or may not be an actual arrest warrant against her. I'm not sure for what, but I will definitely be keeping you guys posted as to what it will be. So the next update I wanted to share with you guys is on Mr. Fagiolo. So Alphonse, if you guys don't know who Alphonse is, Alphonse Fagiolo is a Sovsik guru out of Pennsylvania. And he and I have actually had some back and forth. I was actually kicked out of his Telegram group when he didn't like things that I had to say, but it's okay. I made a sock account and got back in. And his personal endeavor has been he does not want to pay property taxes on the home that his parents lived in. His parents have both been deceased since 2019, and he is arguing that the property is not taxable. The home is not taxable. So he stopped paying taxes or did refuse to pay taxes, and he had been the city naturally issued I believe a lien against his property. He lost his damn mind, claiming that he's not a taxpayer under Pennsylvania's definition. Yada yada yada. That level, that state level or municipal level claim has actually been dismissed. He's then tried to file a federal suit against the county, it's Delaware County in Pennsylvania, as well as the Delaware County officials against her. Against him, I should say. But I'm not going to suffer you guys through his complaint, which is 150 pages long, because of course it is. But I do want to go through one or two of, they might be the same. They might just be the same text with all of them. I want to go through the defendant's motions to dismiss, as well as Fagiolo's response, as well as the judge's order, because he lost. Of course he did. He lost his case about a week ago. So let's go in here. It's okay, Devin. I was being really soy on Sunday night, okay? So don't worry about it. All right, so let me zoom in here so you guys can read it with me. All right. I guess you guys can maybe read this, right? This there. Memorandum in support of defendant's motion to dismiss. I'm pretty sure his name is Alphonse, or at least he pronounces it Alphonse, or is it a way to avoid looking at bigger? This is Alphonse Nicholas Fagiolo, and they are true that his middle name will be important. So there's a claim against defendants in relation to allegations that they have somehow deprived him of various civil rights by improperly assessing real estate taxes on real estate located at 505 Johnson Avenue, here and after the property. Plaintiff's complaint is 150 pages long, has nearly 250 paragraphs, and contains more than 8 counts against various defendants. For brevity and ease of reading, defendants will only address the portions of plaintiff's complaint that pertain directly to claims against them. The complaint should be dismissed for the following reasons. This court lacks subject matter jurisdiction over the claims because plaintiff lacks standing to bring suit as he's not the owner of the property as alleged. So yeah, Fagiolo apparently has the genius idea that he doesn't have to put his name onto the title of the property. But I mean, despite that, yes, under the rules of intestacy, the direct descendants would get the property that his parents had. That's not necessarily that doesn't mean that you can make claims on the property's behalf, and the attorney will get into that too in Pennsylvania law. Court lacks subject matter jurisdiction over the claims because 28 U.S.C. 1341 bars a constitutional challenge to a property tax assessment when the state law remedies available and are available, and here they are, because Yes. I think he only stopped at the municipal level. He never actually appealed his issue. The complainant fails to state a cause of action because the challenge tax scheme is constitutional. Fails to state an action to the extent that any claim is barred by sovereign or governmental immunity. And he also failed to comply with Rule 8 of the FRCP, which mandates that he plead a short and plain statement of his claim. A 150-page complaint is not a short and plain statement. The overarching the overarching theme of plaintiff's confusing and disorderly complaint seems to be that the moving defendants deprived his rights related to the property through the assessment of real estate taxes. A review of the complaint filed by the plaintiff shows that the plaintiff alleged that he is the owner, freeholder, and landowner with or without actual or constructive notice of the property, commonly known as property. However, in this very same paragraph, plaintiff references a deed attached hereto as Exhibit A. A review of this deed shows that the record title holders are Alfonso P. Fagiolo and Margaret J. Fagiolo, husband and wife, by the entireties, and not plaintiff Alfonso Nicholas Fagiolo. Similarly, Exhibit B, attached to the complaint entitled Property Search Report, lists Alfonso Fagiolo and Margaret Fagiolo as the owners of the property. Thus, plaintiff contradicts his own allegations of ownership and thus standing with his own records. Notably, Margaret J. Fagiolo is not a party to these proceedings. Aside from plaintiff's own pleadings, the public record of which this court should take notice further supports that plaintiff lacks standing to bring suit in this matter, as he is not the record title holder of the property. The Recorder of Deeds of Delaware County has searched its records to determine that the title holders of the record for the property are the parents. And he includes an affidavit from the Recorder of Deeds. And notes that the plaintiff has no recorded interest in the property. Further, the Register of Deeds of Delaware County has determined that the decedent's estate was raised for the father in 2019, and his wife was named as the executrix. That's right, because his father passed away first, and his wife became the executrix of the father's estate. No decedent estate has been raised in Delaware County for Margaret J. Fagiolo, because Alphonse thinks that he doesn't have to. And I think based on his reasoning, he thinks that because he didn't register himself as an executrix or the administrator of the estate, his property is absolved from being subject to taxes. I think that's part of his argument. Yeah, it's stupid. Thus, it should be inferred that Margaret J. Fagiolo is still alive. I don't believe she is, actually. Further, by operation of law, Margaret Fagiolo is the sole title holder of the property by right of survivorship as a tenant by the entirety. The plaintiff's complaint is devoid of any allegations that the property was transferred from Margaret to himself and accordingly fails to properly plead any standing in this matter. With respect to the material allegations, plaintiff generally alleges that the defendant has no constitutional authority to assess real estate taxes. A review of the complaint uncovers many references to completely inapplicable provisions of various Pennsylvania tax codes, but appears to completely ignore the applicable provisions of the Pennsylvania assessment law, in particular 53 PA CSA 88 section 8811, under which moving defendants actually proceeded and complied. I'm so shocked that a Salsa guru would selectively choose bits and pieces of law that are irrelevant to the facts of the matter to help support his claim, and omit parts of the law that contradict his claim. I'm so shocked. All right. The complainant fails to allege how moving defendant failed to comply with the said law in any way. Further, 28 U.S.C. 1341 bars a constitutional challenge to a property tax assessment issue when state law remedies are available, and they are available. And then it goes to the legal standard about standing, about subject matter jurisdiction, failure to state a claim, 12b6. All right. Plaintiff's complaint revolves around the alleged harm to his real estate located at the to his property. Unfortunately, he's not the title holder to the property and has no standing to bring the suit based on his own pleadings. For this reason alone, the matter should be dismissed. Article 3, Section 2 extends judicial power to cases and controversies. The plaintiff bears the burden of establishing the standing. Must have suffered some actual injury that can be redressed. But the problem is, because it's not on the record that he's the title holder to the property, he has no standing to challenge the tax assessment to the property. Here, plaintiff makes bald allegations that he owns the property, but contradicts himself by attaching what is believed to be documents showing his parents are still the title holders of the property. And then again, here under 28 USC 1341, the law basically says that if a plaintiff has remedies available to him at the state level when it comes to a challenge over state taxes, they need to exhaust the state remedies first before coming to federal court to challenge. That's what this says. So, see, here, plaintiff has failed to allege he ever sought to challenge the tax assessment of the property on the merits before the Delaware County Board of Assessment or the courts of Pennsylvania. This is most likely because he does not own the property and would not have standing to do so. If he did, the assessment issue could have been dealt with in a plain, speedy, and efficient manner. Delaware County makes the information on how to pursue a tax assessment appeal publicly available on its website, and therefore it should be dismissed. Further, he's going to argue that about the constitutionality of the taxes. Even assuming plaintiff had an actual interest in the property, the ability of the County of Delaware and its constituent bodies to assess and collect taxes upon same is beyond reproach. We begin with the Pennsylvania Constitution, which clearly states all taxes shall be uniform upon the same class of subject with the territorial limits of the authority levying the tax, and shall be levied and collected under general laws. It has been stated that taxation, however, is not a matter of exact science. Hence, absolute equality and perfect uniformity is not required to satisfy the constitutional uniformity requirement. Well, that's convenient. Some practical inequalities are obviously anticipated, and so long as the taxing scheme does not impose a substantially unequal tax burdens, rough uniformity with a limited amount of variation is permitted. A taxpayer who believes he has been subject to an unequal taxation due to an allegedly unconstitutional statute must demonstrate the enactment results in some form of classification. Such classification is unreasonable and not rationally related to any legitimate state purpose. When this court is presented with such a challenge, it must remain cognizant of the General Assembly's broad authority and wide discretion in taxing matters, and the presumption of constitutionality afforded to statutes. Statutes of codes. Thus, oh, no, no, skip. Thus, a tax enactment would not be invalidated unless it is clearly, palpably, and plainly violates the Constitution, end quote. Against this burden, moving defendants point to the court to review the general laws of Pennsylvania, and in particular, pencil assessment law, in particular 53 PA CSA, section 8811, subjects of local taxation which state in pertinent part. Except as provided in subsection B, all subjects of property made taxable by the laws of this Commonwealth for county, city, borough, town, township, and school district purposes shall, as provided in this chapter, be valued and assessed at the annual rates, including all 1. Real estate, namely houses, manufactured homes, and mobile homes permanently attached to land or connected with water, gas, electric, or sewer facilities. Buildings permanently attached to the land or connected with water, gas, electric, or sewage facilities. Lands, lots of ground and ground rents, trailer parks, and parking lots. So, Fagiolo, in his response, he's going to somehow magic or illogic lord his way into saying that his parents' house, his parents' home is not real estate or is not a house. There is no doubt, and there has never been any, that buildings are real estate and are therefore taxable as such. The enabling statute authorizing the imposition of a tax clearly states that the county may assess a tax as real estate buildings. Movements note that plaintiff's complaint makes various references that moving defendants' actions are somehow violative of the provisions of Title 71, Taxation and Fiscal Affairs of Pennsylvania of the PSA. However, this title, 72 PS 7401, refer to the Pennsylvania corporate net income tax provisions and have no bearing in this matter. Of course it doesn't. Any citations of plaintiff to legal interpretations of such statute throughout this complaint are accordingly non sequitur. Similarly, plaintiff reference to 72 PS 4728 102 definitions are only relevant to the Affordable Housing Unit Tax Exemption Act. The definitions cited with respect to 72 PS 7201 regarding real estate structures are relevant to education. The above list of miscitations of law and statutory provisions are meant to be illustrative and not exhaustive. The examples strewn about the complaint are unfortunately legion to address them all. True. That's how it works with these guys. You file a 150-page a document full of bull, and then it's on the defendants to try and decipher all the mess that they create. By plaintiff's own admission, the property at issue is a residential home. Clearly, the property as described in the very deed attached to plaintiff's complaint is real estate, as contemplated under the above referenced statute. Accordingly, the constitutional ability of the County of Delaware to assess the property should not be in question, and the entire case should be dismissed. True. Further, to the extent that plaintiff claims any recovery of funds paid for the real estate taxes of the property on the mistaken belief that he is the owner of record, he is not entitled to such relief under the voluntary payment doctrine. And then I'm not going to go through this because this is the 11th Amendment, sovereign immunity, which is kind of notable. But I want to go to the footnote. What's these two footnotes? It is notable that plaintiff has not alleged that defendants improperly assessed the property, or that the implementation of the assessment scheme itself is unconstitutional, and the allegations do not support an inference for consideration by this court. Immunity. Short and plain statement. The short and plain statement. With 150 pages inclusive of exhibits and nearly 250 paragraphs, plaintiff's complaint certainly meets the definition of voluminous and unfocused and fails to give any defendants the notice of what claims plaintiff is asserting against them. Filled with lengthy and irrelevant quotations of what plaintiff deems is controlling law, parsing out the anecdotes, legal conclusions, and relevant pieces of information from the actual facts that plaintiff intends to apply to each claim is, at best, a significant undertaking and at worst, virtually impossible. The complaint entirely fails to communicate to the defendant what the claims are against him and under what theory plaintiff alleges he's entitled to relief. As such, the complaint should be dismissed in its entirety. So that's one. This is the another. This is on behalf of the. I think this is the tax collector, but I think it's largely the same thing as before. Again, this is also for the County of Delaware and the Tax Bureau. Again, largely the same. Here is this guy's response to the motion to dismiss, filed on November 30th of this year. Plaintiffs supplemental memorandum in support of denying defendants 12B. B16. It's 12B6, you jackass. Plaintiff, Fagiolo, the sole biological son, child, heir, descendant of the parents, exercising actual and constructed dominion with legal possession and fee simple interest in the property. Acquired through inherent and indefeasible right. With substantial possession and a clear constitutional standing in all family property to maintain its action in accordance with Title 42, USC Section 1983. And then it goes into quotes. Now, I believe here he's citing the intestacy statute. The share of the estate, if any, to which the surviving spouse is not entitled. The entire estate, if there's no surviving spouse, shall pass in the following order to the issue of the decedent. Real property on the death of an ancestor vests immediately in the heirs, whether they are known or unknown, and regardless of whether the estate has been or is being an administrator. The heirs, as a general rule, take legal title with right to possession and control. I mean, which to me kind of sounds like it kind of sounds valid. But I don't think that it's enough. It's enough to where, like, he can't be removed from the property. But whether or not he can make a challenge to the tax, I think he still needs to put on record that he is the title owner. But again, the defense attorney will talk about this too. Under the view that title passes immediately, passage of title to the heirs does not require settlement of the estate or appropriate order declaring heirship, and heirs' rights entitled to property do not originate in the decree of distribution but are derived from the decedent under the statute of distribution. Passage of title to real estate to the heirs does not require settlement of the estate or the court order declaring heirship. Recording a probate certificate of device or descent is necessary only to perfect marketable title. The certificate produces evidence that the heirs or devicee's title is no longer in danger of being cut off by a probate sale to pay the debts of the estate and furnishes a record of who received. But that's it. That's right there, though. Recording of a probate certificate of device or descent is necessary only to perfect marketable title. The certificate furnishes evidence that the heirs or devicee's title is no longer in danger of being cut off by a probate sale to pay the debts of the estate and furnishes a record of who received title. But that's what you need. That is the potential heir. It's not relevant. About him being in fee simple. Fee simple ownership. The term fee simple a fee simple absolute is a form of ownership in which property has unlimited power to sell, transfer. It's a party has unlimited power to sell, transfer, alienate, or bequeath the property in any lawful manner. Restraints upon the power of the owner of an absolute estate to determine its devolution by will or by intestacy have been generally struck down. The term fee simple, properly defined, refers to the extent of an alienability one would enjoy in the ownership of land. Black's Law Dictionary defines a fee simple estate as one in which the owner is entitled to the entire property with unconditional power of disposition during his life and descending to his heirs and legal representatives upon his death intestate. The term legal representatives, as used in the statute relating to the descent of an ancestral estate, means descendants. Yeah, legal representatives, though. It is a fact that property ownership is a substantive right and guarantee. The plaintiff can't be a taxpayer and tax just because he owns property. Nobody argued that just because you own property, you're therefore subject to tax. Nobody said that. So straw man argument. To do so is clearly an unconstitutional application of Pennsylvania Tax Reform Code of 1971 and therefore is an action under color of law. Oh boy. Drink. AKA simulated legal process, assigning an arbitrary assessment value to plaintiff's non-commercial property and placing it on a commercial ad valorem tax roll. In order to tax it constitutes taxing the plaintiff's right to own property. Note that he's, again, going back to citing the commercial portion of the Pennsylvania tax code, and not what the defense attorney showcase, that there are provisions in the Pennsylvania tax code that involve non-commercial real estate. It's equivalent to assigning an arbitrary assessment value to this right to free speech and then taxing it. It's well-established law in the United States that rights can't be taxed. Such difficulties indicate that the dichotomy between personal liberties and property rights is a false one. Property does not have rights. People have rights. The right to enjoy property without lawful deprivation, no less than the right to speak or the right to travel, is in truth a personal right, whether the property in question be a welfare check, a home, or a savings account. In fact, a fundamental interdependence exists between the personal right to liberty and a personal right in property. Neither could have meaning without the other. That aims in property are basic civil rights as long as recognized. That's not a problem. I don't have an issue with what he quoted. It's just that it's irrelevant to the matter at hand. He needs to put in somewhere that said that the state cannot tax property. I believe since the country's founding, property taxes has been a thing, including those on non-commercial estates. The act now under consideration does not impose direct taxation of property solely because of its ownership, but the tax is within the class which Congress is authorized to lay and collect under Article 1, Section 8, Clause 1, and generally described as taxes, duties, imposed excises upon which the limitation that they shall be uniform throughout the United States. Within the category of indirect taxation, as we shall have further occasion to show, is embraced a tax upon business done in a corporate capacity, whether the subject matter of the tax is imposed in the act under consideration. In the present case, the tax is not payable unless there be a carrying on of business or in a designated capacity. Okay, so he's quoting what? What is he quoting? Actually, Flint versus Stone Tracy Company. So again, he's citing an issue involving a company and a company's property taxes, not a residential, not a non-commercial entity. And again, these are federal. This is an issue with involving federal taxation, not residential taxation. So again, the citation is irrelevant because we're talking about Pennsylvania state taxes, not federal taxes. Tax Reform Code of 1971 was intended to clarify the tax laws of the Commonwealth. Article 4 of the code specifically sets forth the corporate net. Why are you talking about the corporate net income tax? Again, he's going right back to if this thing actually wants to respond to the attorney, what he needs to do is say, no, 72 PS 7401 is actually valid with regards to this property, is a valid citation, is applicable to this property because of X, Y, and Z. And he would challenge what the defense attorney said, but he's not. He's just reciting probably the same exact arguments that he put in his complaint. Why does the corporate net income tax, corporate net income tax, that part of the code, why is that relevant to his parents' property? And why is the Title 52 part of the Pennsylvania law, why is that irrelevant or not applicable? That's what he's supposed to be doing, but he's not. See, he's talking about income arising from transaction activity in regular course of the taxpayer's trade or business. Again, he's going in. Yeah. All right, going to 28 U.S. Filed a Title 42, 1983 civil action for deprivation of rights. Plaintiff is not a statutory taxpayer by any stretch of the legal definitions, and nowhere in the plaintiff pleading does he challenge the constitutionality of the tax code or the Commonwealth of Pennsylvania and its political subdivision's authority to levy statutory taxpayer entities. Which, well, that's a conclusory statement, but sure, or well. Defendants have intentionally perverted and misapplied the tax statutes of the Commonwealth by placing the plaintiff non-commercial property home on the County of Delaware's commercial ad valorem tax roll. It is equally well settled that the revenue laws relate only to taxpayers. No procedure is prescribed for a non-taxpayer where the government seeks to levy on property belonging to him for the collection of another's tax, and no attempt has been made to annul the ordinary rights remedies of a non-taxpayer in such cases. The government sought to levy on property of A for tax liability owing by B. A could not and would not be required to pay the tax under protest and then institute an action to recover the amount paid. His remedy would go into a court of a competent jurisdiction and join the government from proceeding against his property. But the problem, so what is he saying here? Let me read this again. If the government sought to levy on the property of A for tax liability owing by B, A could not and would not be required to pay the tax on the protest and then institute an action to recover the amount paid. But he's not arguing that this is his situation, though. He is full-throatedly arguing that he is the title owner of property A, and the county is saying that you owe a tax related to property A. So this quote is irrelevant to his circumstances by his own admission. These constitute special and compelling reasons why courts, in scrutinizing taxing acts like here involved, should be acute to distinguish between exaction and unexaction, in which, in substance, in reality, is what it pretends to be in the scheme to lay a tax upon a non-taxable subject by a deceptive use of words. But if the fact that a tax ostensibly laid upon a taxable subject is to be measured by the value of the non-taxable subject at once, suggests the probability that it was the latter rather than the former that the lawmaker sought to reach. If inquiry discloses persuasive grounds for the conclusion that such is the real purpose and effect of the legislation, the tax cannot be upheld without subverting the well-established rule that what cannot be done directly because of constitutional restriction cannot be accomplished indirectly by legislation which accomplishes the same result. Constitutional provisions, whether operating by way of grant or limitation, are to be enforced according to the letter and spirit and cannot be evaded by any legislation which, though not in terms trespassing on the letter, yet in substance, in effect, destroying the grant or limitation. So he's trying to say that the current tax scheme, he says he's not challenging the constitutionality of the tax scheme, but here he's trying to challenge the constitutionality of the tax scheme. The individual, like a corporation, cannot be taxed for the mere privilege of existing. No one is saying that you're being taxed for the privilege of existing. The corporation is an artificial entity which owes its existence and charter powers to the state, but the individual's right to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. Again, no one is arguing that he's being taxed for existing. They are taxing his property. Under these cases, like to note, if you rent, you're not subject to property taxes, right? The rent, the I guess the share of the property taxes for the building is probably baked into the rent, but you're not paying. The county is not directly assessing you property taxes for your apartment. Under these cases, the state must provide procedural safeguards against the unlawful tax exaction because such exaction constitutes a deprivation a property under the due process clause. Thus, a post-deprivation refund action, the state must provide not only a fair opportunity to challenge the accuracy and legal validity of the tax obligation, but also a clear and certain remedy for any erroneous or unlawful tax collection. The due process clause of the 14th Amendment requires the state to afford meaningful post-payment relief for taxes already paid pursuant to a tax scheme ultimately found in the Constitution. They do exist. They do exist. They're arguing that it does exist. Why are you doing this? They're arguing that it does exist and that you did not exhaust those existing remedies. All right, so here's the I believe this is the last response by the defense attorney before the judge's order, which I'll be showcasing. So memorandum of law support defendants' respective motions to dismiss. One, the plaintiff lacks standing because he never probated his mother's estate. As previously argued in the matter, plaintiff lacks standing as he does not hold title and is not the owner of property located in Ridley Park that is the subject of this matter with respect to the complaint that property taxes are being assessed and collected against same. As previously noted, plaintiff is not a named party to the copy of the deed which was attached to the complaint. Further, contrary to plaintiff's representations in court, title does not automatically transfer to him upon his parents' death as the allegedly only intestate heir. There is a process in Pennsylvania for such transfer of title, one that is explained below, and which it appears plaintiff has not attempted to comply with it to establish title to the property. To have standing, the plaintiff needs to have some personal stake in the case. That is, the plaintiff must have suffered an injury in fact, a concrete and imminent harm to a legally protected interest like property or money that is fairly traceable to the challenged conduct and likely to be addressed by the lawsuit. So let's look at the footnote. A deed cannot exist without a grantee. Further, any deed must be recorded with recorded with a recorder of deeds in which the property is situated to put all parties on notice of the interest. As previously briefed in this matter, plaintiff has never recorded his property interest in the matter. He never recorded it because he's a moron. The right to property must appear on the face of a deed for there to be a lawful conveyance. Highland versus Commonwealth, 400 PA 261. Where's footnote 3? Heeding the court's instruction at the October 31st, 2023 hearing to attempt to locate standing cases where a party is not on a deed and specific finding. After diligent search, undersigned counsel is unable to find precedents which were exactly on point, but feels necessary to provide the following analysis and discussion for consideration. While not controlling precedent in the circuit, with due candor to the court of the Fifth Circuit has held that although plaintiffs, quote, may ultimately fail to prove ownership or any property interest entitlement to the property issued in their takings claim, end quote, they nonetheless had standing because their complaint, quote, asserted an interest in the property dispute sufficient to meet the minimum constitutional requirements of Article 3. The Seventh Circuit has established such a similar precedent. We have not found any case law suggesting that these principles have been expressly adopted by the U.S. Supreme Court, the Third Circuit Court, or with the Eastern District of Pennsylvania. See, now this is an attorney, unlike sovereign citizens and unlike sovereign citizen gurus, this is an attorney acting in good faith. This is what attorneys are supposed to do in a situation like this. Is to note case law that may be potentially adversarial to their claim, but also noting that this is none of these cases are controlling because Pennsylvania's in the Third Circuit, and these are and the cases cited are in the Fifth and the Seventh Circuits. But this is the attorney doing his due diligence and acting in good faith. Second, I'm sorry. I'll be right back. Cristo. Okay. All right. The transfer. Sorry. The transfer of property of a decedent, in this case, plaintiff's mother, who is believed to have passed away in 2019 based upon death notices posted to the internet, would be governed by Pennsylvania's probate estates and fiduciary code statute. In particular, 20 PCSA Section 302B states, legal title to all real estate of a decedent shall pass at his death to his heirs or devisees, subject, however, to all the powers granted to the personal representative by this title and lawfully by the will and to all orders of the court. Emphasis added. Informative to the understanding of this language are the following definitions. Personal representative means an executor or administrator of any description. Will means a written will, codicil, or testamentary writing. Thus, while a natural heir may have a right to take a decedent's real property, they must still apply to the appropriate register of wills with jurisdiction for this right to have this right recognized and, if necessary, determined. Indeed, in interpreting similar language as found in Section 302B in an earlier statute on the subject matter, the Pennsylvania Supreme Court found that a sole heir has the right to take and distribute real property, but only after the right to be a personal representative has been established. Indeed, the Quality Lumber Court concluded until a distribution has been made, the only proper source for a full title of the decedent was the administratrix. This precedent has been recognized as a controlling precedent under the new code as well. Tom Cashman, thank you for the $5. Some people are so smart they don't know how dumb they are. That is literally the definition of the Dunning-Kruger effect. So, yes. And most, if not all, sovereign citizens and their gurus are all suffering through the Dunning-Kruger effect, for sure. Oh no. Oh no, they have something controlling here. Indeed, the importance of an orderly and lawful transfer of title through the probate process has increased importance in future challenges to the legitimacy of the title, as was discussed in the matter in Ray Cowden, where the court reviewed the assignment of an interest made by an heir to his parents' property that occurred before the property was distributed to the heir by the personal representative. There, the Cowden court noted the following: until distribution of specifically devised realty is made from an estate to a devisee, the proper source of full legal title in such realty is in both the devisee and in the personal representative. 2. A devisee can convey his or her interest in pre-distribution pursuant to an assignment, that such assignment need not be in any particular form, and that the assignment can even be oral. Mr. Shuckler, thank you for the $5 super chat. 3. An expectancy of an inheritance can be transferred by assignment. 4. Neither the mother's realty nor the father's realty has been distributed to the debtor in 1993, when the debtor allegedly conveyed away her interest in the same to herself and her husband, and a distribution of specifically devised realty must ultimately be made to the specific devisee, notwithstanding the title that such devisee possesses in realty as of the date of the death of the devising decedent. Thus, Cowden explained that where a property is distributed by a will, under Pennsylvania law, a devisee of realty obtains via will, as of date of the testator's death, not just bare legal title to realty, but rather full title to realty, both legal and equitable, subject to potential devisement by the estate representative. Further, under Pennsylvania law, the devisee conveyed both legal and equitable title. Subject to devisement to her parents' wills prior to the estate representative's distribution of the assets. Here, No will has been probated nor estate raised with the Delaware County Register of Wills, which would have jurisdiction over the estate. To become the personal representative of an estate, an heir must file a petition, among other things. A copy of the death certificate, a representation of the relationship of the petitioner as the descendant, and either the will or a sworn statement that no will could be located, all of which made by under oath. Still, he didn't do it. According to the affidavit, no letters were applied or issued. As such, the existence of any will is unknown as a matter of public record. While distribution of the real estate in this matter may ultimately rest with the plaintiff, he may not be the only intestate heir, or there may even be a will. Further, by obtaining letters from the Register of Wills, a personal representative subjects himself to the jurisdiction of the orphans court for that county. Long story short, and short story shorter, Fagiolo may actually be the owner. What? What's going on in chat? Anyway. Well, the thing is, Fagiolo may be the rightful heir and the rightful owner, but he didn't make that known to the county. As far as the county is concerned, the parents are still the title holders of the property. Anyway, Akira, thank you for the $5. We note that the death of the mother is not conceded as an established fact, and the record as plaintiff has not produced a copy of her death certificate, but the above is submitted to the extent that such incident may have in fact occurred, and what controlling law will be with respect to her administrator of her estate. In short, it is defendant's position that the death of his mother does not provide standing to plaintiff as a property owner in its own right, as this right of title has not been clearly established by not pursuing the process of obtaining either letters, testamentary, or administration, and transferring said title subject to the inheritance laws and taxes. Here they're reestablishing that the county does have a right to assess taxes on his property. But I wanted to note, like, just how stupid he is, that he thinks that just because he declares himself as the son, which he probably is, I'm not even necessarily denying that, in the eyes of the county, in the eyes of the tax assessor, and by rights, in the eyes of the court, he's not the actual title holder. His parents are. So let's go into the actual order. Yeah? Nope, that's not it.
Through the years, we all will be together. If the fates allow.
I know I downloaded it. Hold on, I'm sorry. Hold on.
Faithful friends who are dear to us, gather near
I know I had it. Darn it. Where is it?
once more. Through the years, we all will be together. If the fates allow.
Uh,
A shining star above the highest.
oh, I think this is his motion for reconsideration, which is 162 pages because he's an idiot again.
A merry little Christmas.
Where is the order? I think he included the order in here. Ay, Dios mío. Well, this is the motion for reconsideration. Oh my God. Why? Oh, this is his motion to reconsideration, which is 52 pages. I'm sorry. Okay, here we go. All right. Found it. All right, here it is. Here's the order that they're granting the defendant's motion to dismiss, but he puts his facts and the facts and conclusions into the footnote. On May 18th, he filed a complaint asserting that they improperly assess the assess the tax. Plaintiff seeks injunctive and equitable relief for this court to declare the property not to be taxable under the law. He also alleges that to avoid tax liens, his parents and later himself paid taxes on the property from 1977 to 2023. He's also seeking that amount to be returned to him as real damages because he's a moron. Yeah, he wants all the property taxes that he and his parents paid to be returned to him. Yeah, okay. He's also seeking compensatory damages. Defendants submit that plaintiff's parents, not him, own the property because they are named the owner of the deed of record. And for this reason, plaintiffs lack standing to challenge the tax assessment. Regardless, as will be discussed below, the court lacks subject matter jurisdiction over an action stemming from a challenged state real estate tax, so the court need not reach the issue of standing. So ultimately, it's not really, it's kind of boring in a sense that the court didn't talk about him being really, really stupid in not registering or not officially holding himself out as having title to the property. But it said basically that the state of Pennsylvania already has remedies available for him to challenge the tax assessment. And therefore dismissed. It's dismissed with, I think, with prejudice. I don't know if with prejudice, but it's dismissed. He then tried to file a reconsideration, which he does as part of this, saying, "Oh my God, how dare you!" And then he's probably going to try and sue the judge, because that's usually how these guys operate, or file a bar grievance against the judge as a retaliatory action. So yeah, he lost outright. He lost completely and fully, but of course it doesn't change anything He doubles down, triples down, saying they're all corrupt. Yada, 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 yada. Oh my God, my, oh. All right. We're going to finish up with a court hearing, and then we're going to call it there. One second here. Beth, I'm not having a stroke, okay? I'm fine. No, Goddess, I'm holding off on that. I might save that for later, honestly, though. All right, let's hear about this sovereign citizen who tries to pull something in open court.
Our first case this afternoon is People of the State of Michigan versus Trevor McLeod. It's file 23-6748FH. Counsel, you want to state your appearance, please?
Anthony Julian on behalf of people.
Okay, Mr. McLeod, are you present, sir?
Yeah.
You want to come on up to the table here?
I want to reserve all my rights.
That's fine. I'll all right, so Mr. McLeod, this is the time and date scheduled for what's called for a circuit court arraignment. The case having been bound over to this court by the district court. So you're here representing yourself today, is that correct?
Yeah. What's
that?
Yep.
Okay. So I'm required by law to make sure that I've taken an initial waiver of your right to counsel in this court. So I covered a pre-trial hearing in the district court, so we talked a little bit about this, but now it's up in my court. So you've got two constitutional rights. You can have you have the constitutional right to be represented by an attorney, and if you wanted to have an attorney at public expense and qualified, to have that. You also do have the right under our Constitution to represent yourself. Obviously, you can't do both things at the same time. So do you understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay. And do you wish to represent yourself instead of having an attorney?
Yeah, I'm here by special appearance, and I will be representing myself.
Okay. I'm required by law, before I accept that waiver, to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or a $100 to $500 fine. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Oh no.
Okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No.
Hold on. I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on. I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble. Okay. Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or a $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is?
Nature and cause.
How much the fine is that I've articulated? Can you tell me what
I
it
don't
is you don't
understand the
understand?
nature and cause of the action against me because there's no established jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? Is that okay?
No.
Okay. So one step at a time, I need to establish that you're exercising your constitutional right to represent yourself validly. So for me to do that, somebody might decide they want to do that and they really don't understand what's at stake. So I have to establish on the record that you do understand what's at
Well, I
stake.
think you have to establish on the record first that you can have jurisdiction. That's been a question. It was questioned in preliminary hearing. It was never.
Oh, that was a declaratory statement right there. It sounds like Mark Stevens, classic Mark Stevens script. Yes,
Addressed.
but it could also be the Talking Frog script.
I'll address that today.
Well, it has to be addressed before anything can move forward, obviously.
Okay, so you want me to explain to you why I have jurisdiction?
Yes.
Okay, let's do
Which
that first.
jurisdiction it's under.
Sure. Okay. This court has subject matter jurisdiction over crimes punishable by more than a year as the court of general jurisdiction under the Michigan Constitution of 1963. The people voted to ratify that Constitution. That is the underlying law of our sovereign state of Michigan.
Okay, so is that a jurisdiction under criminal? Or is it military?
Yeah, it's a criminal.
Okay, so that he said criminal or military tribe. You know, this is the Talking Frog. Yep, this is the Talking Frog.
Charge against you, and I have jurisdiction over that.
Okay, so the Constitution of the United States only grants you two.
There it is. Yep,
One's common
of
law,
course.
and one is military tribunal venue.
That is the Talking Frog, aka use of L.
Article 1, Section 8, Clause 17 of the Constitution, which of these two criminal jurisdictions is that?
You're not in federal court. It's not a federal crime you've been charged with. You've been charged with violating the law of the state of Michigan. And hey, what's going on over there? What are you doing, sir?
I'm trying to make sure that this is going live. It's not happening. There's something.
What? Wait. What? Wait, who the hell is this?
Messed up with your film, and I'm trying to straighten it out. I was just checking to see if it was recording or not.
Sit down. Sit down. You're disrupting my courtroom.
Sorry, sir.
It's live. Any more disruptions, I'm going to ask you to leave.
So, common law.
McLeod, you're in a state.
Wait, is this the actual BSBT or is this a sock account? Okay, BSBT. It's funny, it's great, but knock it off. You're actually starting to annoy people with the bit, and it's funny, but please knock it off, or else I'm going to actually ban you. Okay, thank you.
Court. You're charged with violating a law of the state of Michigan.
And is that a statutory jurisdiction? What is it?
Yeah, it's a statute. And
Okay, so-
and this court is duly authorized under the Article 6 of the Michigan Constitution. So that's my jurisdiction.
Okay,
So now I need to make sure that you're establishing your right to represent yourself. So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine.
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution.
Yeah, he's going right back to the script now.
So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what?
No, actually, Gary, this actually is part of the script. This is an ad-lib. The script actually anticipates this kind of answer from the judge, but let's see but only this far. Let's see where it goes from here.
Statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General
The
jurisdiction.
people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. The legislative power is exercised by the House of Representatives and the state Senate. They have passed statutes that the governor has signed. The prosecutor's office is alleging that you have violated those statutes. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So, Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
No.
One second.
He doesn't understand.
I
Because
can
the
see
script.
why his attorney would do. Oh, shit.
Ah!
Hang on. Someone in the prosecutor's office is not muted. I'm going to.
Oh no! Oh no! Oh no! Somebody from the prosecutor's office. Oh, she had a hot mic. She had a hot mic moment. Oh, that's great. That's funny.
From the meeting at this time.
Oh.
Prosecutor's office is generally allowed to.
She said, "Oh shit!" When you realize this, get a hot mic.
To observe. They've participated. I'm removing them from the hearing.
Oh man, that's great.
Mr. McLeod, do you understand the maximum penalty that you could face?
One second. Okay, so when enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city.
Oh my God! Now he's going into the cases. Yeah. So the script doesn't take him this far. So now he's going into the cases taken out of context.
I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I challenged subject matter jurisdiction and nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection.
He literally just addressed it. He literally just addressed it.
It exists under the Constitution.
Your objection is noted. So, Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on. I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod, stop.
the court can be.
Stop, Mr. McLeod. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
I've challenged this court's jurisdiction. You haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
and now he's trying to ignore what the judge is saying and continuing to recite his BS, which isn't a good idea.
I have other matters, Mr. McLeod. You know, I understand you want to object to things, and you're going to be allowed to object to things. Okay, sure. But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. and I can hold you in contempt, and you'll go back to a jail cell for a while.
No, Your
and then
Honor,
we'll
I don't wish to be held in contempt. I'm just wishing to exercise my Sixth Amendment right.
That's fine.
And
So before I can let you under,
I can
before I
cite
can,
laws. I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying it enough to where I can comprehend it.
Well, if you can't comprehend it after this point, the judge is probably going to rule you incompetent to move forward on your own.
you can comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong, and you can appeal.
There's no such thing as a statutory jurisdiction.
Mr. McLeod, let me make this simple for you.
Hey, Marge.
You ever watch, let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that?
So,
Mr. McLeod, Mr.
Oh my
McLeod,
God.
two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges. Mr.
Mr. McLeod is in contempt of court, taken into custody.
Really?
Well.
My rights is very
Fucking Joe.
This isn't true. You guys are
Follow unconstitutional
following
orders.
unlawful orders. It's not constitutional at all.
Mr. McLeod's in contempt and sentenced to 1 day in Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is
notice.
about the Constitution. I did nothing wrong except to question and exercise my rights.
Mr. Mathis and Mr. White.
Mm-hmm. That it? That's it. Hold on. I still have like half of this left. All right. Who was that? Omega, the your mom jokes doesn't work from chat to me. All right. It only works from me to chat. So nice try. Wasn't there didn't somebody have a sovereign citizen that involved a bork nom nom that I missed? If it is, I haven't seen it yet. I think Biggin showcased it, didn't he? Yeah, Fur Missile. I don't know from DFW. I don't want to know from DFW, okay? Oh God, an auditor tries it? Okay, we're gonna go to DK. All right, I haven't seen this from DK. All right, shout out to DK.
Welcome to the Dummy Cougar channel, everyone. Today's video takes place on an unknown highway located in Brentwood, California, to check in on First Amendment auditor NorCal Cop Watch. We usually find NorCal Cop Watch at well-known tyrannical hotspots like the post office, waste management offices, and even emergency service office buildings. He seems to have a knack of turning every single government interaction he has into a theatrical production, which is mostly what all this boils down to, isn't it? Well, at least for the time being, he has hung up his harasser of low-level employees hat and decided to don a newer, fresher, I'm not driving, I'm traveling hat. But before we get to the fun part, please remember to subscribe, get notified, like, and comment below. Let's jump right in.
Never. I will never sub to you. Wait, what?
Hi, sir. I'm Officer Green. The reason I stopped you is your third brake lamp's out, and then your reflective coating of your license plate's all messed up.
Reflective coating?
Okay, so I gotta say, I've noticed that a lot of the California auditors, why do they all look similar? They got the same beard. They are all wearing like a similar snapback. I don't know. Maybe it's just me, but I feel like a lot of auditors in California like have the same look.
What's your name and badge number?
Green 574.
574. You mind if I get out and look at it?
Not right now.
Not right now?
Nope. Do you have your driver's
You
license?
sure? Because I check all my lights before I leave my house.
Okay, just
All right, everyone, please raise your
Yeah, I was gonna raise your hand if you check your lights every single time before you drive out. If you're raising your hand right now in chat, you are a goddamn liar.
hand if you believe this auditor actually checks all of his vehicle's light bulbs before getting into his conveyance. Anyone? No? We've heard some whoppers from First Amendment auditors before, but this one just may be the most ridiculous.
third brake lamp. It's the one in the center.
Yeah.
Okay. Do you have your driver's license?
I do.
Okay. Can I have it?
Can you call your supervisor?
No, not right now. I need your driver's license.
Well, I just told you I
Call your
check all
mom.
my lights before I leave.
Okay. That's fine.
Just so you know, you are being recorded, live streamed. Yeah. So call your supervisor, please.
No. I need your driver's
No.
license.
Okay. So I just told you I check all my lights.
Okay. I understand that.
Yeah.
Okay.
Before I leave my house.
Okay.
Wait, Lord Bacon, there's also a video of two Moors that duck and cover behind a Macy's counter screaming their heads off. They are being targeted by lasers. Wait, Lord Bacon, do you have a link to that?
I got what you're saying.
Yeah.
I need your driver's license.
Am I committing a crime?
No, it's a traffic violation.
It's a traffic violation?
Yep.
Yeah, I'm not driving, I'm traveling.
Did everyone hear that? That's the sweet sound of bullshit. I'm not surprised that a First Amendment auditor,
Oh, he said the thing. He said the thing, people.
typically not known for their intellectual prowess, would fall for this soft-sit nonsense.
Okay.
Yeah.
Well, I still need your driver's license.
I don't have a driver's license.
Wait. Just 1 minute ago you said this.
Third brake lamp. It's the one in the center.
Yeah,
Okay. Do you have your driver's license?
I do.
So which one is it, Freedom Fighter? I thought you guys were all about the truth and
Oh, it's an older one? Okay.
transparency. Weird.
Okay.
Yeah.
Okay. Well, what's your name?
I don't have to give it.
Well, yes, you do.
No, not unless I'm committing a crime.
Well, you're committing a traffic
You
violation.
can call your supervisor. Yeah, I'm not engaged in commerce. This is not being used for any kind of purposes related to work. I'm traveling from point A to point B. So you swore an oath to uphold the Constitution, right?
Yes, he did.
Are you calling a supervisor?
Huh?
Are you calling a supervisor?
Yep.
Oh!
Cool.
Linux, I do want to cover that. Hold on. After this.
You're making this much harder than it has to be, but that's fine.
Yeah. You swore an oath to uphold the Constitution, right?
I did.
Yeah. So I'm traveling. I'm not driving.
Okay.
Point A to point B.
Of it, okay?
I'm sorry?
I'm not going to argue with you.
No, I know, because you'd lose. You would lose.
Okay, here goes. Despite the claims of those advocating the right to drive without a driver's license under the banner of the right to travel, it's essential to highlight a stark reality for these guys. No legal precedent or case law supports such a contention. The right to travel is a well-established constitutional principle, but it does not grant individuals immunity from complying with basic traffic regulations, including the requirement for a valid driver's license. In the realm of law, absence speaks volumes, and the lack of any substantial legal backing for this notion underscores the misguided nature of such assertions. As the legal landscape stands, the right to travel doesn't equate to a free pass on licensing requirements, despite what some fervently like to argue.
I'm not committing a crime. I don't need to identify myself. A traffic violation is only for cars that are used in commerce. Right? You understand that?
I'm not going to debate with you.
I know you're not, because you would lose, like I said.
Just one case on the merits. That's all I'm asking for.
And, I told him, I said, I'm not driving, I'm traveling. So, I tried that little thing here because I'm not engaged in commerce. This vehicle is registered in, actually, it's not registered in my name because they misspelled my last name, huh?
Oh, yeah.
So it's not, the vehicle's not even registered to my name, actually. So.
Why would you
You're
admit
making
that?
this way more difficult than it needs to be. Well, shouldn't have pulled me
He's
over.
right.
If you were just totally cool, totally nice, and you were like, yeah, I'll let you get out and look at it. Let me verify it. If I could verify it, yeah, I'll give you my license. But the only reason why I need to give my license is if I'm operating a motor vehicle and engaged in commerce. And I'm not. I'm literally traveling from point A to point B. So he said he was calling a supervisor. We'll see if a supervisor shows up. Oh, here he comes on the, so they're talking on the back side of the vehicle. See him right there?
Oh, yeah?
Yeah. Looks like there's 3 of them now. So now they're going to try to intimidate me with 3 police officers. So they're all huddled back right here. I'll try to move the camera, see if you guys can see it. So they're back here, right back here. They're talking, trying to discuss how to move forward with this traffic stop.
All right, sir. So we're able to find a match for you, okay?
A match for me?
Yep. All right, we're able to find your driver's license, okay?
Oof. So not only is his conveyance registered, the officer also confirmed that he does indeed have a driver's license, which I guess is different from a traveler's license. The real deal soft sits who have been doing this for years are rolling their eyes right about now.
In the future, pull over right away.
Oh, well, I was actually trying to go somewhere where it's well lit up because you guys are criminals and you guys like to hurt people. So I was trying to go to a place where it was lit up, but
I appreciate that.
unfortunately, I would have had to go down another 2 miles, and then you guys probably would have used excessive force on
All
me.
right,
So.
well, we'll send you the second.
Oh my god.
Oh, no. Look at that. They said they'll send me a citation in the mail.
How does that work?
Wait, how does that work? Well, if they were able to find you in the system, they would find your driver's license, which would have your address, and so they'll just mail you the citation. That's how it works. It's yeah.
Well, that's a great question from our soft sit female partner. Maybe ask your rights protector the next time he's bothering postal employees for some Google bucks. Have him inquire about how to mail things. To get you started, typically an envelope, stamp, and an address are needed. I'll let him figure out the rest of this obviously needed public interest story.
Get out.
Why are you getting out of the car? Why are you getting out of the car?
I need your name and badge number. What's your name and badge number?
Green 574.
What's your name and badge number?
It's gonna be on the citation.
What's your name and badge number? Identify. What's your name and badge number? Who's the supervisor?
I am.
You are? Make him identify. Do your job.
It's right here. Polanco.
It's right here?
Yeah, it's right here.
Are you related to the other right here?
633.
What is it?
633 is my badge
Polanco?
number.
And your name?
Flynn 573.
Flynn 573. Okay, you're dismissed. Go back to work.
Oh, what a tool bag. He had to get that so he can feel good about himself. Which again, most of these sovereign citizens, most of these auditors, usually have a lot of insecurity. I know I'm armchair psychologist, but I don't care anymore. These guys have so many insecurities that I know he had to do that so he can have like the last say and the last laugh. That's usually why they do that. Cringe. They already said you're free to leave, and you're like, you're dismissed. Got him.
Yeah, I'm good. These motherfuckers, they said they were able to find out who I was, and they said they're going to send the citation in the mail.
Yep. Mad, bro? Sounds like you're malding.
I don't get how that works. Oh, it doesn't. Because you have to
Mald
sign
seed.
something about third brake light. Let's go check it.
It is. It's out. And it is out.
And would you look at that, the light bulb was burned out. And of course, SC was proven right once again. You really do have to light a fraudit. I know this wasn't the most action-packed soft sit available right now, but I decided to cover it for a specific reason. First Amendment auditors and sovereign citizens, at first glance, may seem like two distinct groups with different agendas, but beneath the surface, they share a common thread of anti-authority and anti-government sentiments. Both movements attract individuals who harbor a deep-seated skepticism towards established institutions and a desire to challenge perceived encroachments on their rights. On one hand, First Amendment auditors, often armed with cameras and an alleged passion for constitutional rights, engage in confrontational encounters with law enforcement and government officials to scrutinize and try to expose potential abuses of power. On the other hand, sovereign citizens take a more radical approach, rejecting traditional legal frameworks and asserting a form of individual sovereignty that often clashes with established laws. Despite the difference in tactics, the core ideology unifying these groups lies in their resistance to authority. That, and of course their receptivity for clicks on their YouTube channel. Whether challenging government officials on the streets or refusing to acknowledge legal norms in court, both First Amendment auditors and sovereign citizens share an overarching disdain for established systems of power, making them similar players in the broader landscape of anti-authoritarian movements. Tightening all that up really quickly, I believe there is a natural progression from First Amendment auditor to sovereign citizen.
I agree with that. I do believe that First Amendment auditors is like on the pipeline to going full soft
because of their anti-authority views, and because a lot of them are probably powerless in their real lives. They want to try to pretend powerful in front of actual powerful people. So in the end, I think we may see more First Amendment auditors trying to go this route, which, to be honest, is always quite entertaining. Alright guys, I think that's what we end today's video. Please do remember to subscribe, like, and comment below for similar content. This is Dummy Kruger, and I'll see you guys on the next video.
A little bit left. Wait, have I seen this one already?
For a fact that those blue flashing lights in.
Yes, I have actually. Yeah. Have I?
Also, it's probably not a good idea to call your dogs your children when the conditions they're being kept in are being reported as
Yeah, I think we have seen that one. Yeah, never mind. All right, so
Promise you, they're gonna fix you up.
So, Mandy, I know you shared this one to me before, but I felt like it was at least the raw footage was pretty rough. So, but I do see now Donut Operator just posted his take on it, and so I feel like he do a good job of cutting out some of the rough parts. But this is a wild incident that happened in Houston. Was it in Houston? I believe it was Houston. Because Houston apparently has all the shootouts. This is nuts. But this one was actually wild. I know I could have shared it first, but it was pretty rough. But at least we see it.
Man, I've been to state jail once. The last time I was locked up, man, they offered me 25 years, man. I had no choice but to get out and change my life. Hey, I'm still here with you, buddy. You hear me? What's your name? My name's John, too.
Hi everyone, Donut here. Today we're going to be breaking down a really wild shooting involving a high-speed chase, an officer being shot, and a civilian bystander dragging that officer to safety. There are so many good angles to this wild-ass shooting. We got like 5 different body cams and 3 different cell phone footages, so much footage. Yes, this shooting did happen a couple of weeks ago, but the body camera footage was just released. I'm going to show you the viral cell phone footage from the civilian who pulled the officer to safety also. That was what...
Oh, wait. There's a Bork Bork Nom. Oh, that was the Bork Bork Nom Nom. It was on Code Blue Cam. I missed that. Yes, this one is an ex-con actually grabs an officer who was shot in the shootout and drags him actually to safety. I know, it's spoiler, but the reason I didn't want to throw it is because it's pretty the raw footage that was uploaded was pretty rough. Mostly because it's the shooter's like a freaking 19-year-old and making a really stupid mistake and constantly making a stupid mistake. But you know, what can you do when you're 19 years old? That's what you do, is make stupid ass mistakes. That's why I didn't want to showcase this, but I want to see the Nom Nom. Hold on. Code Blue Cam. Yeah, there it is. There it is.
In June 2023, an officer was on routine patrol with his furry companion Canine Jocko when he observed a black vehicle without a license plate in Monona, Wisconsin.
Why's it got to be a black vehicle? Huh?
Furthermore, it was known that this is a commonly employed tactic by car thieves. The driver was later identified as a 20-year-old male named Jaquan. Records indicate that he has 2 active arrest warrants and a history of assaultive behavior. Upon initiating a traffic stop, Jaquan quickly accelerated and began driving recklessly, reaching speeds exceeding 100 miles per hour. He continued to show complete disregard for others, maneuvering through traffic at excessively high speeds.
Naturally.
And passing John no plates. They're going to be approaching curb route. Speeds are 100, lane number 103. I'll take mutual aid from Fitchburg or Madison. We're passing Rim Rock now. 100 miles an hour, lane number 3. Approaching park. Looks like we may exit. Never let me stay on it. Pass the park. Speeds are 85. Lane 2. We get into some traffic here. We're approaching Fish.
Thea, we already watched we already watched Noah's latest escapades. I think in the last stream.
Speeds are still 85. Looks like we're set up to exit Fish. Taking the exit.
Alright, they're going northbound Fish Hatch.
Our partner's calling. Perfect. Help everyone.
Speed 50.
I'm Spikes.
Speed 50, who's talking to me right now?
3535. They're going east on West Badger Road.
Copy that. We've got spikes approved from the city and from the county.
5 miles an hour.
Ooh, spikes approved. Let's go.
And northbound park in the southbound lane.
Northbound park in the southbound lane.
deploying.
Ready for a bite, buddy. If this guy foot bails, he's getting dog bit.
Ooh! I really want to work with finding some way for radios to work without them trying to put their hands off the wheel. If somebody else, I mean, I'm sure there are probably some solutions out there. I'm trying to think that, like, you know how like the throat was it? What are those you know, those spec ops, those throat mics? I appreciate they still have to put their finger onto it to trigger the mic on them. So that wouldn't work either. They're still putting their hands off of them. I'm sure there's got to be solutions out there.
Right, north on Catalpa. And northbound fish hatchery.
Yeah, Bluetooth, I think encrypted Bluetooth is a thing. I thought encrypted Bluetooth transmissions are a thing. I don't
And he's on Midland.
Oh, that's also actually Ice Blade. That could also be it. That there could be like a button on the steering wheel that can trigger the Bluetooth mic. That actually could be a solution as well. So all they need to do is use a thumb to trigger the mic.
Eventually, another officer ahead attempted to deploy spike strips on his vehicle. However, it was unsuccessful as Jaquan drove onto the sidewalk.
Northbound park.
Wow, what a rude person.
There's spikes.
He's going northbound in the southbound lane.
Yes.
Northbound in the southbound lane.
He's driving on the sidewalk.
Driving on the sidewalk.
Oh man, Drake.
Cosmore.
Yeah, Drake was
Southbound fish hatch.
Passing so many city squads.
I know. They got everyone out?
Did he hit spikes?
Negative.
Negative, no spikes.
no spikes.
God, that was close though. He almost got him on the sidewalk.
Yeah.
There's another city squad.
Anyway, sorry, eastbound Wingra.
Info for assisting units. Car number 1's got a dog in it. If he foot bails, he's getting dogged.
What? Why did he have the meme on there? The meme Shiba?
Go outbound park. Eugene, call it again.
Outbound park.
He almost rammed the squad. We're headed back towards fish now on Wingra. Towards fish on Wingra.
I need you to go again, one at a time, please.
We're approaching fish from Wingra, and he almost rammed the squad.
Going towards behind the house.
Sorry, passing Spruce. Now Midland. Eugene, you can call it again.
East on Aaron Street.
Eastbound Aaron.
Sorry, Jocko.
A few more officers ahead were able to successfully deploy spike strips on Jaquan's car.
There we go. Bam!
Spike hit, spike hit.
Spike hit.
Oh, watch out!
Nice work.
We got hit.
Did you?
Yeah. Cade 5-3, I've been
Oh no!
ahead of him and slow him down
Friendly fire!
so I don't lose this pursuit.
As the officer tried to stop his vehicle, Jaquan bailed on foot with a firearm. His abandoned vehicle then collided with the officer upon exiting the squad car, briefly trapping the officer between the two vehicles.
He has been spiked, so I can confirm that him and I both have.
Bail, bail.
Mailback, white shirt, khaki pants.
K9 Jocko was then quickly deployed and gave chase.
Here, Jocko here. Here. Jocko here. Jocko here. You still see him, Eugene?
Jaquan was soon observed trying to commit an armed carjacking.
Why with you? Oh my god! All right, let's add a couple. Let's add another major felony to it.
The intended victim rejected his ass.
That's me! Get on the ground! Get on the ground! Get on the ground! Jocko here! Attempted carjacking! Watch out, Eugene! Get on the ground! I'll shoot you! Get on the ground! Watch out, Eugene! Jocko here! 32 in his head!
Jocko, get him!
Selling him, Jocko! Selling him!
As K9 Jocko took him down, Jaquan remained armed with a handgun, but shortly tossed it toward the officers after being bitten.
Well, that'll do it.
Drop the gun! Drop the gun! Drop the f***ing gun! Drop the gun! He's got a gun! He's got a gun! I'm sorry! What a gunpoint!
Oh, now he's sorry.
Roll on your stomach! Okay. My dog's on the bite. He's got a 32. Okay, please. Roll on your stomach! Roll over! I am. Please get him. Arms out! Put your arms out to your side. On your stomach, arms to your side. Hands behind your back, now! Hands behind your back! Do not move. Do not move. Move me. Stay down. I'm sorry, it's right behind you. Where my ride along is.
Man, Jocko sounds gassed.
My squad got destroyed.
I hit you, I'm sorry.
No, the suspect hit me. You're good.
He's apologizing to the officer.
Suspect hit me. I'm good.
You guys both good?
We're good.
I'm bitten.
Yeah, you got bit.
Lay on the ground.
Good.
Okay, I'm sorry, man. Damn.
You had a gun on you. What do you think was gonna happen?
You good? I think so. Okay. K538, we're into an EMS for dog bite. I also got struck by the car.
I'm sorry.
Did anybody secure the suspect vehicle? Hey, okay. Affirm, if you could start EMS. You got a dog bite. Hey, does anyone know where we are right now? Where are we?
We're at 755 Braxton.
755 Braxton, and
I got it on our channel 1.
I don't know if I need EMS from me or not. I got ran over getting out of my car. My squad also got smoked. All right. He tried to. He got hit.
You got any dope on you or something, man?
Oh, yeah.
You got dope or no?
Yeah, where'd you get hit?
I got ran over getting out of my car. It hit me on this side. My squad's destroyed. It ripped.
Oh, look at that poor baby. He is gassed.
My whole driver's door off my car.
Oh, okay. Do you need me to take Jocko?
Okay, yeah, the officer is also gassed. I imagine that, having that kind of gear and then all the adrenaline, and then as soon as probably you're done, the adrenaline goes away, and then I guess I'm only assuming this is what happens, but I imagine it all hits you like a brick, and that kind of ends up happening.
No, I'm good. Okay. My left leg's just starting to hurt a little bit. We're going to need 2 ambulances here for 1 officer and the suspect with a dog bite. Off, Jocko. Yeah.
The officer, I think he said his leg was run over. So
you got dope. Where you hurt,
no,
buddy?
I think I'm going to be fine. The adrenaline's wearing off, starting to hurt a little bit. I got hit on my left side.
yeah, see, so he said what I was saying.
So he tried to carjack somebody in a silver SUV over there.
No, I didn't.
Says, the f you did? Shut up.
Like, bro, we got you on body cam. It's like, the hell you did it.
So, he tried to carjack somebody that was sitting in a silver vehicle over there.
Trying to take cover.
So, somebody need to talk to them as well.
I think I should be good. I just didn't check my mirror. I jumped out of my squad and the car ran me over.
All right, man, you can tell that to your defense attorney.
Glad your fucking dog recognized that it was me.
My squad's destroyed.
Yeah, I think so. I didn't see anybody else get out of the car. Okay.
You okay?
Yeah. Oh, I'm just out of shape.
Good boy, buddy. Good boy, John. That's a good boy, Bubba.
Where'd you get run over, buddy?
Just on the passenger side. I jumped up on the hood of the car.
Where did you get hit with their car, buddy?
Yeah, this side.
This side?
I should be good. The adrenaline's just worn off and sore.
We're going to swap TAC 13.
Yeah, I don't see anything bleeding.
I think I'll be fine.
Okay.
Squad's destroyed.
I'm going to call.
He's probably gonna get he's probably gonna get sore, and it's probably gonna be. I mean, depending on how hard he got hit, he's probably gonna have a bruise on there like a mother. That night or the next morning.
Actually, my car. My car. Minus 2. Okay. Well, you wait here. Jocko Nay. He might bite you. Be careful. Yeah, he's growling already. Did that guy leave?
The firearm was soon recovered, which was loaded with 1 round in the chamber and reported as stolen.
You got a bag of dope, load a gun. Nice. He had it in his fucking hand when we came around the corner here. He almost got shot.
Yeah, honest to God, he's actually lucky to be alive, because I honestly think that the cops had him dead to rights because he did not throw the gun as he was on the ground being bit by the dog. There was about like 5 to 10 seconds. The cops telling him to throw out the gun, that he still held onto it before he ultimately threw it. So he's actually kind of lucky, because the cops, I would have said at that point the cops probably would have had justification to use lethal force.
I was right behind you. Yes, would you? Yeah. Holy yes, please, thank you.
You all right?
I should be fine. I jumped out of my car and got ran over. I didn't know the car was still in drive.
Is he got a toy or something for his mouth? Or is he in the
No.
Your car's
yeah,
your front door. You want me to just put him in the back?
Yeah, it's fine.
Okay.
If you want. I should be fine. Well, one, I'm going to switch to RR. I'm going to tell her she should probably call thirds then. Okay.
When he was caught, I'm not even talking about the chase. I'm not even talking about the chase. I'm talking about at the moment right there where they're at that corner, when the dog finally caught up to him and bit him. It still was probably between 5 to 10 seconds of the officers yelling at him to drop the gun before he ultimately chucked the gun.
My fucking squad got it. We can't just replace a K9 car. No. K9 squad missing a door. 38 got hit by a car and is injured, but up.
Well, that's going to be a lot of paperwork.
Going to get checked out. Can you call 8510 or whatever and see? We should probably start third shift in early. It's going to take a bit. Okay, dope was in front and right pocket.
Yep.
This was on him, and then gun I saw.
Yep. Is he a felon?
Oh.
We want DNA if he's a felon.
Okay, yeah, no idea.
I got these on.
Okay, perfect, thank you. What
We
was
need a
that?
paper bag.
Oh, paper bag?
Paper bag for guns if we want DNA.
Yeah, yep.
We should transfer the drugs to paper as soon as possible.
Okay. Me and the other injured cop are the only ones on in Monona.
Okay.
So I'm going to have to see how many Madison cops I can steal.
Sure.
Is he getting transported, you know?
Oh, I'm sure. Where's his car at?
Out on the street. I think his car's totaled.
Oh, okay.
Jaquan 35, copy at 29. Perfect. Thank you very much. First name, Jaquan. Further, it looks like K9 officers getting transported to a hospital, so we're gonna need more. We're gonna need more bodies here. Okay. Okay. I'm gonna go grab a car.
Okay. It sounds like Schmitz is already here.
Okay. Would somebody be able to go up to the hospital with him and stand with him for now?
Okay.
Is that the 95's property?
Yes.
Are there keys?
No.
Oh, no. The vehicle is locked, and the trunk is locked too, so we can't get in the trunk right now.
Okay.
So we're having Schmitz come out. They can probably prop it open for us.
I think what we'll do probably just because we might just put a hold on it. We'll let our detectives worry about getting a fucking warrant, and then they can dig through it. So, yeah, I guess I'll go to
Stolen.
Fucking fantastic.
All the charges.
Trying to carjack the guy up?
No, it was in.
Possession of a stolen handgun, possession of a controlled substance, fleeing and eluding, attempted carjacking. Yeah, he's getting all the charges.
Oh, in this parking lot?
Yep.
Do you have the case numbers off that offhand? Stolen from us. I haven't looked in the case yet. And then this is the serial number of the gun. I'll remove it right now from NCIC.
As a result of the 10-mile pursuit, Jaquan was charged with felony counts of operator fleeing, eluding an officer, causing bodily harm, second-degree recklessly endangering safety, possession of
the Daryl Brooks special
of a firearm, and possession of stolen property.
It's a
All
twofer.
charges are repeaters. With the 2 active
Naturally.
warrants at the time of this arrest, he is also a fugitive from the Wisconsin Department of Corrections, serving community supervision for a previous conviction related to illegal gun possession. The officer caught between the 2 vehicles was taken to a nearby hospital, sustaining non-life-threatening injuries. In the meantime, K9 Jocko was picked up by one of his buds from a neighboring department.
Yay!
Jaquan's cash bond was set at $60,000. Visit code.
All right, look. At least it's not like $1,000 signature bond. Okay. I mean, the bar is low. The bar is extremely low when it comes to Wisconsin.
Bluecam.com and treat your.
So I'll take the $60K bond as an improvement. All right. I will. This is it. I'm all done with the tier. Well, not done with the holiday tier beer that I've collected. I actually have another 12-pack of cans that I'm saving for my trip. Which, by the way, guys, I'm going to my sister's for Christmas on Saturday. Gonna be a lot of fun. My brother will actually be able to come out there and visit as well, so I'll get to see my brother and the family, and my little niece, who is the cutest niece on the face of this planet. Yeah, but as far as tomorrow I'm probably going to stream. I think I'm going to stream tomorrow, and I'll probably stream on Friday. But I'm heading out. I'm driving out there on Saturday morning. But yeah, that's gonna be the schedule. So I hope you guys have a good rest of your night. Stay safe. Stay warm if you're out in the northern hemisphere. If you're in the south, stay cool. But you guys have a good night. Take care. Adios. See ya.